Welcome to Lessons from Litigators. This is a webinar series that the firm has put on, and it's been actually really quite well received. I mean, litigators are used to being in the courtroom and not, giving presentations like this, I think. And it's generally I think more the corporate team that goes around doing a lot of this stuff, I would think. And then when we started this series, every week we get 250 people, 300, sometimes a little bit more signing up. So we really appreciate everybody's interest. And it makes us want to get out of bed in the morning and give these presentations. So thank you so much for coming. I think the reason why we started Lessons from Litigators is because what we've found is that when you're in the trenches, when you're in the courtroom and you're fighting about a contract, when you're fighting the U.S. government, when you're defending a client against a prosecution by a state prosecutor, you learn a lot, and you learn how the prosecutor thinks. You learn how the government thinks. You learn how provisions of a statute actually function in real life. And so, when we come back to the office and I'm sitting there with Matt Vicari after being in court, we have a lot to talk about and we've learned a lot. And so we're hoping to kind of pass that on in some of those lessons that we've learned in the trenches to you all. And in fact, more and more, I think, at least in my practice, I've been advising clients on how to mitigate risk in the event of, say, a subpoena being served or a government raid. And I feel like all that experience that we have, makes it so much easier to really cross the T's and dot the I's. So hopefully you'll learn something today. Our presentation is called What to Do When the Government Knocks on the Door. And it's hopefully catchy enough. It's maybe not fully complete, and we'll get to that. But today we're not going to be providing legal advice. So here's the disclaimer.
Every lawyer has to have one of these, don't they?
You do. Sometimes at the beginning of a phone call with a client, sometimes I want to say, now this isn't legal advice. So I should have this disclaimer wherever I go. But today, we're going to talk about the dawn raid or the service of a subpoena. And, whenever a client calls Matt or I saying, hey, I just got served with a subpoena, or, hey, the government is literally at my front door, they feel like they're the only company or the only person that's ever had that happen to them. And it's a nightmare scenario for a lot of folks. And, I guess the good news is that you're not alone. Matt and I have a very full practice. Matt's practice potentially is even more focused on this than mine. I want to give a real quick background here. Matt Vicari is a member of the firm, and he's the chair of the firm's white collar practice group, which includes government investigations, which is what we're really talking about today. And then, you've got criminal law. Matt's been defending people in the courtroom for how many years now, Matt?
I'm on my 31st year here at Miller Johnson, so it's been fun.
Yeah, that's a long time. So he, his practice is focused on representing business entities, executives, healthcare, medical, and other professionals and other individuals in complex and civil disputes, as well as criminal and investigatory matters involving a wide range of corporate, government, and individual crimes. There's really no one better at Miller Johnson to be talking about what we're going to talk about today, because Matt, for the last 30 years, has been handling these very things. And he's very modest, and he won't spend a lot of time talking about his bio. So I thought I would here real quick. All of these logos that you see up here, the Department of Justice, the Federal Bureau of Investigation, the EPA, the U.S. Department of Homeland Security, pretty much every agency you can think of, Matt has defended a client in connection with. And, Matt takes great pride in the work, and I've learned amazing amounts from Matt over the years. I came here 6 years ago from a large firm based in Chicago. And, I showed up, I remember almost 7 years ago now in my interview with Matt Vicari, and we started talking about these very things. And I just said, well, I've got a lot of white collar background. I do a lot of white collar civil and criminal defense. And he said, well, we do that here. and I said, okay, well, that's good, because I'd love to work with you. I'd love to get in the trenches with you. So, both of us have an extensive background. Recently in the last few years, we've had a couple big subpoenas that we've dealt with, grand jury subpoenas, even civil subpoenas from the U.S. Department of Justice and other places. So we've worked together, we've worked separately, we've worked individually, and all of that informs kind of all the work that we do. My practice recently has been focusing a lot on data breach response, which is governed mostly by the state attorney general's office. So the regulatory investigations that I've been handling in connection with cybersecurity and technology transactions have largely involved the state attorney general's office and things of that nature. So just
Jason, if I can, before we get into the slides and some of the information, I welcome everybody. I'm very happy to be here, and Jason and I handle a lot of this. And I just want to tell you that it impacts every kind of industry you can think of. And most recently, we've been having a lot of healthcare grand jury subpoenas. There's been a lot of healthcare fraud investigations, but it doesn't discriminate against any industry. We've handled matters in the technology sector, educational institutions. I've handled matters in school districts, landscape, greenhouse, agricultural industries, especially with immigration and ICE, with raids and grand jury subpoenas, the trucking and logistics industries, professional services, accounting, architecture, engineering, even legal, and of course, manufacturing. A lot of our manufacturing clients have gotten knocks on the door. And so today, what we're hoping to do is to get you thinking about having a plan and be prepared, because when it happens, you want to be able to put something in process and going, instead of, oh my goodness, the FBI is here. And so you'll have a plan if that occurs. But thanks, Jason.
I think that's good, because, I was looking at the attendance list that Amy, our marketing person, handed us yesterday. And, we've got people here from across all industries. And you're right, the government does not discriminate in terms of what industry they want information from. So, with that kind of background, let's kind of dive right in here. So, let's say today, instead of fighting the rain, you were sitting at work and, knock, knock, there's someone at the door. And, this sounds maybe like a movie a little bit, but it's exactly what happens. The FBI or some law enforcement official, will knock on a door and, very politely say good morning and, potentially hand you a search warrant and say, I'm here to execute a search warrant. And so, that happens, and it happens to a lot of companies. And, sometimes it's not because it's not necessarily, I should say, because the company has done something wrong or an executive has done something wrong. They may just want to make sure that the evidence that they collect pursuant to a search warrant is what I would say potentially like untainted. It's fresh. There's been no opportunity for the company or an executive to move a box or delete a file or do whatever. So the reason that they do it kind of on a surprise basis is they want to know exactly what's just laying around and potentially pick it up. And so, you've got the execution of the search warrant. And then after that, you're going to potentially be dealing with direct requests from authorities, from the FBI, from whoever related to things. I guess right here is the moment where I would literally pause and I would say, I welcome, maybe the person to sit down in the front lobby, no further than that, and say, just one moment, I need to contact counsel. And, it sounds potentially gratuitous, but I've had to say it at the dozens and dozens and dozens of presentations over the years, is the first thing that you should do is call, company counsel if you have one, and then company counsel should call outside counsel, or you should just call outside counsel directly. And we'll get more into that, but the reason why that piece of advice isn't gratuitous, and we can explain that a bit later, is that because what Matt and I do, the value, one of the biggest values we bring, and Matt and I were talking about this yesterday, is we bring the attorney-client privilege and the attorney work product privilege, and potentially any other privilege that exists under law we can assert on behalf of the company, and assert it for you in a manner that immediately diffuses the situation. And in fact, Matt, you can probably tell us from example kind of how that, in that heated moment where the CEO is kind of losing their mind, they're nervous and upset, or the director of HR is nervous, upset, they're on the phone with you and they say, Matt, there's someone serving a search warrant, what do I do? And you say, tell them Matt Vicari and counsel is on his way.
Right.
And immediately it settles at least the company executives. And I think, and you can tell us more, I think it settles the government too, because
Absolutely. They
they know that they've got a professional. I mean, literally, this is their job. This is our job. And we know how to do the job that needs to happen that day in a professional manner that doesn't upset their search warrant, that doesn't upset what they want to do necessarily. And actually protects the client and the government in the sense that nothing weird happens, such that evidence is tainted or there's a privilege issue. So Matt, what is your experience there in that first moment?
Thanks, Jason. And just to back up a little bit, sometimes when the FBI or DEA or immigration or Homeland Security, whatever federal agency or state agency or county agency comes to knock on the door, a lot of times they may have multiple law enforcement officers. I think the most I've had is about 29 in an EPA raid. And so a lot is going on. And so when Jason says to contact in-house counsel if you have it, or outside counsel, what we can do is we can calm everything down. And I can tell you, most of the time, I get there, I say, hey, I talk to the agent directly. And one of the first things we say is we'll cooperate in any way that we can, but we want everything going through counsel, like Jason said, to help with the privilege, but also to narrow things down and to have some control over a process that law enforcement wants to control, and they do control when they come in with their flak jackets on, and they make an appearance like that because they want to scare people a little bit. And so it always helps. And then we get out there as soon as we can and help monitor, and that kind of gets into some of the other issues that we'll be talking about.
Absolutely. And so, what we've found, I think, over the years is once Matt gets involved and I'm there to assist Matt, there's a common language that the government and counsel have. And it only comes after years of kind of working together with the government to say, hey, I understand what your goals are today and you understand what my goals are today. And let's just get through this day in a calm, professional manner. And we don't want the employees of the company to, get really nervous or scared. And we don't want any evidence to be tainted either. We want, the custody and control issues to be handled. So it kind of, immediately sets the stage for what's going to happen. So to kind of keep moving along here, this slide, focuses on executing a search warrant, and it's, the tip here is to review the search warrant, determine the areas to be searched and what's to be seized. I guess in my mind, a lot of times it's all the computers.
Yes.
And all the paper files, sitting around. And so they've got a routine, and it's a routine. Matt, I guess, I haven't given you this question in advance, but I think you can probably handle it. And what if it's not a search warrant? What if it's just a subpoena?
Yes.
What happens?
Well, then you got to make sure that it's been ordered by a court, or under the administrative rules, it's allowed. And so one of the first things we like to do is get a copy of that subpoena. There's a lot of different subpoenas. Some get issued by the courts, some are administrative in nature. And so it's important that we're able to see that, one, it's authentic, two, the scope of it, because a lot of times these are extremely broad. And so sometimes we can narrow them, especially if I find out who the prosecutor is, right? A federal prosecutor, an assistant United States attorney, or someone from the Attorney General's office in Michigan or wherever, or a local prosecutor. And that way we can try to hone in on what is it that they actually want. And so, especially with a subpoena. And so that's the way that you can effectively respond to it, but yet at the same time, not give other things that maybe they're not seeking. So.
Absolutely. And I think, that's the key is, whether it's a search warrant or a subpoena, I think of the search warrant as, we want it today. And I think of the subpoena as, we want it, as soon as you can get it to us. And, sometimes it takes a couple of weeks to respond to a subpoena. Sometimes it takes a couple of years. But either way, you want to sift through and figure out, okay, what do they really want, and how do we narrow the scope so that they don't get a bunch of stuff that they don't need? In fact, the government doesn't want things they don't need either, or they don't want things that are protected by attorney-client privilege, because then they have privilege issues later on, and they don't want that. So everybody wants to kind of follow the rules and get through what's going on. So, let's say law enforcement has made it past the lobby in our scenario here. And now they're back in the office area where there's like 4 or 5 cubicles and a couple executive offices. And the FBI says to someone, head of HR that's kind of directing them around. So where are the servers? Are they on premise? Or are they, in the cloud? Where do we direct that type of inquiry? Does the head of HR just start going on and on about the way the network is set up and how things are handled? What does she do at that moment?
Yeah, we don't want that's part of getting counsel involved, because it could be more easily responded to. And so when whoever is showing the law enforcement, whether that's HR or an executive or a plant manager or somebody, I think you have to very much limit the responses you give. And so, and it's always better to get somebody else involved, like the lawyer, so you're not going down a path of many, many questions by the agent, and then you're giving a lot of information that otherwise you may not have to give, or you may not really know about, and you may think you have to know about it, but you don't. And so it may be easier to say, we can get answers to those questions, but I'm going to have you go through this lawyer or this person. And that's the best way to do it, because one, you're not going to say something maybe you don't know about. Two, you're not going to say something that might be privileged or information that you don't want to give out. And three, you don't want to lie to a federal agent or an officer, because that in and of itself could be a crime. But you just want to be able to get it to someone else so that they can control the situation. And that someone else is a lawyer. And it's easier, like Jason said, because I normally speak their language and I can, or Jason can, or one of the other lawyers in our white collar group can navigate through that. Because one of the other big issues is, why are they there? Is the company a target or subject of their criminal investigation, Jason? Or does the company simply just have documents that may be relevant to another criminal investigation that they're handling that has nothing to do with the company? And so those are things you can figure out fairly quickly, and it helps on how we respond. Because if the company or an executive or owner is somehow a subject or target of the criminal investigation, then we may react a lot differently and be much more strict about what it is we give them, what it is we respond to, and that sort of thing. And I know that got a little long-winded, but hopefully that answers it.
I think you bring up a really good point, Matt, because when you said, target, subject, or witness, that's kind of, code words in our line of work for how is this whole thing, what is the status of our client in the eyes of the government? Are they the potential bad actor? Are they a potential witness to a bad act? Or are they just the storehouse for a lot of good information? And so, if they're the target, what Matt means, I think, and he can probably say it better than me, but there may be some bad, they may be the bad actor. And that's when it's really important to have counsel kind of managing everything, because in a criminal context, you may have, the company itself may have a Fifth Amendment privilege to assert, to say, to say, we'd love to talk to you further and fully cooperate, but we need to take a look at what this server has or this computer has or what these documents say, because there may be something in there that we need to assert a privilege for. And once the cat is out of the bag, so to speak, and you've said, A, B, or C, it's hard to pull that back.
Yes.
You can't put the toothpaste back in the tube. And so when Matt says direct everything through counsel, it's not for his job security or my job security. It's that we're the perfect filter to know when to speak to the government and what to say to the government. Not for any bad reason or to deceive. It's just we know when to stop talking and when a privilege may apply and when all those rules apply. And actually the government appreciates that. The one thing, I think one misconception that I think a lot of clients have had over the years vis-a-vis the government is that, they're going to be upset when we assert a privilege, or they're going to not like when we want a subpoena to be handled this way or that way. No, it's the opposite. If the company, has privilege issues, or the executive has privilege issues, it may delay everything. And we may end up in court talking about those privilege issues and with the judge, and no one wants to be talking about privilege issues when they could be getting to the heart of the matter and getting done with the investigation. So, to Matt's point earlier, you may not want the head of HR or the CFO or the CEO speaking to the government during the search, or even the search in connection with responding to a subpoena, but you're going to want to write down kind of everything that's happened that day, because you're not going to remember it even later that night at dinner, because it's going to be it can be a very stressful day, very intense for everybody. And, you're going to want to make a log of, what they looked at, what offices they went into, what boxes they did. And, Matt is, I think, the perfect example for someone like me. Wherever we go, whatever we do, he's got his legal pad there and he's taking notes and he's writing down everything. And, it's because details matter in investigation, words matter in investigation. Every detail matters in an investigation. And a lot of times folks don't understand that. They feel like Matt and I are just making work or being overly cautious or whatever. But every word that is said to the government, you can't take back. Every document that you give to the government, you can't take back. And it could, that word, that document, that area that they search could change the whole dynamic and the whole outcome of a 2-year investigation or a multi-million-dollar fine or potentially even jail time.
Yes.
And so we don't know in the moment, because we've probably parachuted in, if that word or that document is going to change the whole dynamic of what's happening. But we know, based on our experience, that that can happen. And like Matt, you know, you've handled what? You know, the FBI showing up at like a trucking company, the FBI showing up at a manufacturing plant. Yes. You've handled all those. And I guess, you know, as you're kind of monitoring things and taking notes and handling things, you know, what, to kind of segue into the next slide, like, what are you thinking about in terms of privilege and confidential documents when the FBI says, okay, I want to grab that box of documents?
Right. And so part of the help that can be given is those documents or that computer, they may have records that are necessary for operating the business. And so we're going to want to have a copy of those, or at least try to make an image of whatever, you know, computers are taking, so that the business can continue to operate. Or we get an agreement from the agent that after they image it and they do it maybe in 24 hours, that we can get the computer back. But that's a way of trying to, you know, protect the client and the company, or a manufacturing client. And then if there's confidential things and trade secrets and privileged documents, then we try to separate some of those out, so that, or at least alert that there's privileged documents there, so that they're not handed over, and we can at least assert the privilege. The other thing that's important is talking with all the employees and everybody, because it gets excited that we don't want anybody, you know, destroying documents, concealing anything. We don't want anybody falsifying anything. We want everything to be saved. And so if there's, you know, things that are automatically getting deleted based on, you know, data processes, then you want those to stop. And so those are the kinds of things that have to happen, because, you know, the last thing you want is for the FBI or the U.S. Attorney's Office to somehow get a process crime because you didn't, you know, preserve all the necessary evidence and that may be, you know, asked for in this subpoena, this search warrant, or this grand jury subpoena.
Attorneys have been protecting client data since 1897. And what I mean by that is, you know, Michigan under common law recognized the attorney-client privilege and kind of related doctrines around that time. And the attorney-client privilege is one of the oldest protections that exist. And so over the, you know, last, you know, over that time period, there's a well-settled set of law and rules as to how that privilege operates. So there's an assertion of privilege, and then there's you have to back that privilege up with reasons why it's privilege. And so, you know, privilege exists when there's a confidential communication between attorney and client for the purposes of providing legal advice. That's the basic definition. Yet that basic definition over the years has been, you know, interpreted in a way that, you know, during a search, you know, you can assert the privilege, and it may not be a silver bullet at the moment to stop, say, something be collected, but it's gonna pause everything for a moment. and those pauses may be the most important thing ever. And it may just be so that tomorrow you can operate, right? I think Matt brings up a good point. We're not only there to say, protect you from prosecution 8 months, 12 months, 2 years down the road, but we're there to help you operate the next day. And if you're nervous and you're excited and you're just handing over things, you may need that to operate the next day. And we can be like, trust us, agent, let us make a forensic image of that file. We'll get it to you within the week. And they'll say, 9 times out of 10, they'll say, okay, right?
Yeah.
So
those couple times they'll say, no way, we're coming in here and we're getting it, in which case they get it. And then we try to work on that later through the prosecutor and or the agent. So.
Yeah. And, and here's where, I think my expertise really comes into play. I'm co-chair of the Privacy and Technology Transactions Group. And, one of the reasons why I went and got SIP certified, I'm a certified information privacy professional since 2016, is because I saw during my kind of white collar work and the data breach response work kind of how the impact of having gigabytes and gigabytes and gigabytes of data everywhere and no plan, no policy in place to say, okay, if we've held on to this for 7 years, we can probably delete it. And we haven't looked at it, we can probably delete it. And in the frustration, Matt, that you and I have, I think sometimes when our client gets a subpoena and we need to produce documents to the government and they say, oh yeah, you can have my email file. And the email file is like 75 gigabytes, which means that they've never deleted an email since the beginning of time. And now the subpoena asks for all emails from this executive from 2014 to present related to A, B, and C topic. And that one request with 25 gigabytes in an email file, that's a $200,000 request, at least. And why is it that much? It's because we have to take that email file, we have to give it to a vendor that spends their expertise and their computer time and their expensive software, and so it costs a lot of money. They process that, they put it on a system called Relativity or some similar system, and then a bunch of associates, paralegals, have to go through and say, does this document respond to that request? Yes, no. Does this document respond to that request? Yes, no. And so, kind of arising out of that, I thought, okay, how can we proactively protect our clients from this type of even just, financial risk? Because I don't know about you, but if you're a small business and your revenue is $1 million a year, $1.5 million a year, going through that process is not feasible. It's cost prohibitive. And so instead of knowing what every document says before you hand it to the government, you may just, as a matter of fact, have to just hand all the documents over. And that's an extreme case, but that's what we're dealing with right now. We've got several investigations ongoing. A couple of them are very, very expensive because there's never been a proactive step to say, should we delete this file? And the same thing happens in my privacy and technology transactions world is, clients call me up and they say, I have this subpoena, what do I do? And we find out that they've got gigabytes of data from the beginning of time. They have shadow IT, which means they have, HR was kind of doing their own saving and filing of documents and no one knew about it. And then we find, 100 gigabytes of potentially relevant information. Well, what I do in my practice now, a lot of times is I say, okay, well, let's sit down and let's talk about how data comes into your organization and how it comes out. And let's think about it strategically. What happens if your technology service provider goes down? Can you operate? Do you have the data? Where is the data stored? When do you delete it? And just the simple act of deletion can save hundreds of thousands of dollars.
And clearly this is how you see one of the great many talents of Jason Crow. I'm the one with the gray hair here. And so when we start talking gigabytes and all these other things, Jason knows exactly what he's doing, but it's a good segue into the fact that each company, each one of our clients, we like to get them a communication plan now on what to do. And so this is the telephone tree, we call it, and you can arrange it however you want. But this is one of the things we talk to clients about, and it's imperative to have this because things are very hectic when the FBI comes. And like Jason and I have said, they may be there just to serve a subpoena, but typically they want to try to talk to people. They want to, they've got names of employees or executives. And so this is why you need to be, have a plan and be able to have the individuals that are going to most be involved and need to know that, hey, this morning we got a knock on the door and they're here. And so you can pick what heads of departments or other things, but I think you ought to keep it to a smaller number, don't you, Jason?
Yeah, and we've got this mock, phone tree up here. And really it's all about worst case scenario, right? So, let's say the C-suite is in a board meeting offsite, and the only person there that's really, of kind of managerial level is the senior HR manager. So, what is the cell phone number of the CEO? What is the cell phone number of the attorney? And in fact, it's funny because people think of like these incident response plans or the search warrant response plans or subpoena response plans as potentially a complicated thing. And really, sometimes what I say is, that's it. You're looking at it. There it is, the phone tree. And maybe instead of attorney at the bottom, should be at the top.
Yeah.
And maybe that's the number one person to call. In fact, one of the biggest incidents we dealt with a client based on the East Coast. That's what he said after this incident happened. He said, Jason, I've got this beautiful plan put together. He said, you know what? The first thing I did when I looked at the plan when the thing happened was I saw the phone tree that said, call my attorney. And that's what I did. And he said, I'm so glad I did that first instead of second, because everything kind of worked out a little better. So, what do you do? How do you handle the employees? I think that's where there's a lot of, judgment involved and a lot of, there's not clear rules here. I mean, there's best practices, but it's like, do you inform all employees because you've got the FBI walking around? Maybe they've seen it. How do you collect the inspection record? Who's gonna hold on to that? And in that sense, that's where I feel like the CEO in collaboration with the attorney, that's where it becomes really important for those two people to kind of work together, because the CEO knows their employees better than anybody, and they're going to know, who to talk to, what the next steps really should be from an operational perspective. And the attorney can advise the CEO related to, what the next steps are in connection with the investigation. So, here's some other suggestions. Cease contact with competitor companies. I guess the point of what Matt and I think like to say to companies right after the kind of dust settles, so to speak, is, all right, we're in a circle of trust, impenetrable bubble of attorney-client privilege. You don't talk to anybody about the investigation. You don't breathe to anybody about the investigation. You don't intimate. You don't text. You don't email. You don't talk to your spouse. at this point, all communications related to the investigation are done. And the only communications you should have is between the company and counsel. And I can't stress this enough. In fact, I just had an AUSA, call me the other day because, a client had run into someone at the grocery store, and it was, tertiary, kind of related potentially to the matter. And, the person was just being polite, said hi, but that even became an issue. And so, you just put the circle of trust around the bubble, whatever you want to call it, and, we're done. And then really, I think the important work next, Matt, is to conduct the internal investigation.
Yeah.
And that's where I think you really shine, because, it's a methodical, sort of painstaking process, but it's what happens. I mean, what do you do to conduct the internal investigation?
Yeah, and those are important because you want to figure out, what exposure does the company have? Is there an executive or another employee that may be involved or alleged to be involved? And so you want to try to figure out the facts. And sometimes, a lot of times, the government or the prosecutors will tell you what they're doing and what the allegations are and what evidence they think they have. And so it helps when we come in and want to interview employees and talk to employees. And I know further on, we've got Upjohn rules that we need to talk about, and because we represent the company, but yet we want the employee to be truthful and honest and give every, bit of information that they know about whatever these allegations are. And they have a duty of loyalty, obviously, to their employer to do that. And so that's the very important part. And then we gather that, and then that can all be kept within the attorney-client privilege. And then we can more easily talk with the executives and officers of the company and owners about, this is what we think, and here's a plan, moving forward. So.
Yeah. And, some of the sort of basic formal steps are, you'll get a letter from us saying you gotta stop all deletion of everything, and you've got to hold on to everything. It'll be about a 3 or 4 page letter sometimes, but the bottom line is, don't delete anything, stop all routine deletions, that sort of thing. And really, sometimes, sometimes we get into this, a little bit of a debate with the company about the extent of the internal investigation that should happen afterwards. And I guess we would always just advise, to move forward with the internal investigation. I mean, you're going to have to do some investigation to respond to the subpoena or respond to the search warrant. And, at that point, you want to get your ducks in a row. You want to know what happened before the government knows what happened. And the only way you can do that is to conduct an internal investigation and to work through the process. And, it can take some time, and sometimes you get to the heart of the matter within the first day.
Yeah. One case we had, and this was some years ago, but it was for a school district, a fairly large school district. And we conducted an internal investigation that lasted 60 days, but interviewed, over 20 employees or other folks that were connected with the school district. And then ultimately we had a 144-page report that we gave to in-house counsel, as well as, we spoke with the board and had a much smaller summary report to the board. But ultimately, in that investigation, there were 7 or 8 federal indictments that came out of that investigation with that school district. And so it's important to have a strategy and to talk with the client too about what needs to be done, because the company has to protect itself. And so if there's an executive that may potentially have criminal exposure or another employee, fine, maybe we need to get the executive their own attorney, and we'll talk about that in a second, but the company is who we represent. And so the company has to do the right thing and move forward to try to find out what's happened here. And then if we have an obligation or decide that we want to turn over the results of that, then we can do it. And in this school district investigation, I did just that. I called up the federal prosecutors and said, hey, this is something you're interested in and we know it, and let's sit down and talk about what the results of the internal investigation were.
And, not to belabor it, but, the next like 3 or 4 slides really talk about the same issue, which Matt brought up, is how to best execute the internal investigation such that the company can assert the privileges that it needs to assert. And so, to Matt, what Matt just said is, generally you've got two privileges going on simultaneously, potentially. You've got the privilege between the company, the privilege that the company holds, and then, the counsel that represents the company. And then you've got the executives that may, and this is our next slide, may need to get independent counsel. And that's not a bad thing. In fact, it's how this generally works. And the reason for that is because the company can't assert privilege on behalf of the executive. And so the only way for the executive, who may be the person that was the prime mover in a matter, maybe not a bad actor, but maybe he's the witness, that executive is going to want to be able to understand the full scope of their privileges, and then that can help protect the company as well. And then what ends up happening is the executives counsel and the company counsel enter into a common interest agreement. And
back in the day, those used to be called joint defense agreements. Now it's common interest.
Well, that's right. I think it was even in the PowerPoint as a joint defense agreement, because I came up that way too.
Right.
Let's see. So there was, here's the common interest agreement. I just flipped through all those slides. Essentially, those 3 or 4 slides that I just flipped through very quickly, they all just relate to this concept that Matt and I are talking about here, which is how do we structure an internal investigation to get the facts while protecting the company as much as possible. And then let's say, because I know there's a couple CEOs on the line, I know there's a couple CFOs on the line, I know there's a few head of HR. They may be the person that the government's interested in. And maybe that CEO founded the company. And so there's there may be little distinction in the mind of everyone between the CEO of the company and the company, but there is legally. And so we may want to have, say, Matt Vicari represent the company, and then get, a colleague that we work closely with in town, say at another firm, we don't hoard the work. We get someone that we can work closely with to represent the CEO, and then you enter into what's called a common interest agreement. And what that does, it allows the company and the CEO and counsel for them to share information and protect that information from disclosure from the government. Now, it's not perfect. It's got areas, but Matt and I know those areas, and we know what we can share and we know what we can't share. And so structuring that investigation to protect the CEO, to protect the company, it's not like we're just trying to lawyer up and have the company have to pay for a bunch of lawyers, and but there's reasons for it, and they're well settled reasons. This privilege has been around for a long time, and this is just how it works. And so a couple of these slides, I think, the next step, kind of once you've structured the investigation, you've got counsel for everyone, the government understands who's doing what, what counsel to talk to when they want to talk to the executive, what counsel to talk to when they want to talk to the client. And then, I think this slide brings up a good issue, and I think it speaks to what Matt said earlier, which is cooperation. And despite all of, all the lawyers in the room suddenly, that gives the appearance to say a company or executive that we're not cooperating, it's actually the opposite.
Yes.
Every dime that you spend, every hour that you spend with an attorney, giving that attorney information to give to the government, can later be used in a sentencing memo to reduce any fine or any length of jail time or whatever. All of that time is taken into consideration. All those gigabytes you processed, all those documents you produced, all the proffers that you gave, all the information you gave through counsel, all of that, the government will take into account any sort of leniency that they have, even in charging decisions. So, or decisions to drop an investigation.
Or to make a criminal investigation a civil matter or a civil penalty because you've cooperated along the way. And as Jason indicated, most of the time we are cooperating and we are trying to give the government what they want, the information they want, and to try to show them, hey, this shouldn't be a criminal matter. At best, it's a civil matter. Or even if it is a criminal matter, maybe we can get a diversion agreement so it's not formally charged because we've cooperated and shown them the evidence that we have. And so Jason is right. We're typically wanting to cooperate. And a lot of times, if our company or our client is not the target and maybe be a witness to a subject, then maybe we're giving information that helps them with their overall investigation. And like Jason said, they won't want to charge our client or civilly fine or penalize them. So,
yeah, and I think that's a really, really important point, kind of as we, wrap up. And we've got a few more slides here, but I to me, the issue of cooperation, at least in my mind, 99.9% of the time, there is no question. We are cooperating because even if, I've had clients that have done things wrong and maybe not for any particular reason, or they even didn't know that they were doing things wrong. In fact, at some of my larger clients that we've dealt with, Matt, the executives had no idea what was happening. And so when you cooperate, it makes everything better. It just does. The government is more lenient, especially in the Western District here. We have, I think, really reasonable people, that law enforcement officials, U.S. attorneys, and they, they live in the community. They know that these companies are doing good things in the communities. They don't want to penalize them any more than they may have to. And so cooperation helps everything. And maybe the biggest win that you can get is to have a criminal investigation turn civil, or a civil investigation be completed and drop. And so, a lot of these slides, are really like getting into the weeds. It's how do you handle things with the board? How do you handle them with compliance people? How do you deal with shareholders and regulators? And a lot of those things just require a plan. And you have to sit down after the fact and figure them out. If you're a publicly held company, you're going to have a whole lot of other obligations, mandatory disclosures. And in a lot of these details, Matt and I have a list. These aren't new. We're going to figure out what your disclosures are and your obligations. If you've got whatever issues you have. In fact, one of the first things Matt says to me after a big new investigation comes in, he says, I need a memo on the potential scope of exposure in this case and any reporting obligation. And we just put it together immediately. And that way we can advise the client. You're going to potentially have public relations issues. if, if you're a high profile company in town and there's a high profile search warrant, that may get in the press. And so, having a plan in place is thinking about like, okay, what would we do? Would we issue a press release? And, Matt and I have had dozens of conversations about the efficacy of a press release or a no press release. Now, generally it's people don't want to advertise that the FBI showed up. And that can sometimes come as a surprise to the executives or the HR, the marketing team that's used to managing the story in the press. Like, well, maybe we want to sit quiet for a little while and figure out what's exactly going on. And that's, and that's really this next slide is, don't wait for a crisis to arise before thinking through these issues. And, it reminds me of like, getting ready to do your taxes or getting ready to go to the dentist. You may not want to do it, but like, you need to. And without the proper hygiene, without the, taking those steps to manage your files, manage your documents, understand what's going on and manage your risk, just have a 15-minute conversation with one of us. We don't always turn on the meter. And in fact, when, oftentimes we work with you on 10 other matters. And so you just give us a call, if you have something that you're not sleeping well at night, you're thinking about an issue and you're not sure if there is any legal exposure or you just feel awkward, give us a call. The moment we start talking, the privilege applies. And, we can diffuse a situation. We can make phone calls to the government. Matt knows everybody in town. And so, we can have phone calls and just find out what's going on, and sometimes we get good information. Sometimes we don't, depending on what's happening. But, like I said earlier, the law enforcement officials in town or we've got a good group and, they just want to do things professionally and do them right, just like we do. And we can work together to get a good result for everybody. So, I really appreciate everybody showing up. Today we've got, these lessons from litigators. It's kind of fun to get out there and talk about the things that we've done and the lessons that we've learned so that, when something happens to you all and all of our clients, they know that we've been there, done that, and we can help you through it. So we've got a couple upcoming webinars, and they're great. And they deal with the issues that really only, lawyers have worked through. And once you've worked through them, you understand what to do. So I appreciate everybody showing up today. Thank you so much for your time. I don't know if Matt, if you have anything else you want to add.
No, thank you much.
Message.
Yeah, for showing up, and we appreciate the opportunity to represent a lot of you that are on this call. And again, get prepared, and we'll see you.